Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular episode, I would like to talk about post conviction relief. We have been on somewhat of a roller coaster lately, last few years, give or take, not knowing whether we can do post conviction relief, whether it is dead, whether it's alive, and where it goes from here. So, first, let me just explain a couple things. First, uh, what is post conviction relief and why do you need it? Well, let me just give you a typical example. Somebody at some point in time pled guilty to a crime, generally making them an aggravated felon or ineligible for any realistic immigration relief. And they either are in the process of being deported or they are deported. I can't tell you how many times I get a call from outside the country that tells me, I was deported X number of years ago. I committed this crime. When can I come back? And so, uh, one of the only things that can be done is to try to vacate and or reduce the prior crime so that it isn't considered an aggravated felony or it's not a crime at all if it's completely vacated. And so this will only even have a chance of working if you pled guilty to the particular crime. If you had a jury trial and it went up on appeal, well, then I have other videos for you. This is for the 98% or so of defendants that do take the guilty plea in some way or another. Now, in 2010, the case Padilla came by, and that was a great case. Okay. It basically took prior cases, one of them was Strickland, and other different cases, and it essentially said that a defendant's constitutional Sixth Amendment right of due process includes the right to counsel. And the right to counsel essentially implies that they have to properly advise the defendant of the immigration consequences of the particular crime. So, boilerplate type advisals by the judge saying something like you may be deported, you may not have any, not be able to get naturalized, you may be excluded. We're not talking about that. We're talking about an in-depth conversation with generally an immigration attorney that will let you know what the real immigration consequences are of playing guilty. So if a person pleads guilty to some particular crime and they think there might be some immigration consequences, that's a whole world different than they're, they will be deported. They're an aggravated felon. They'll be deported the rest of their life without any chance of coming back. They'll never see their family again unless their family goes over to their country. And it doesn't matter what family or place they have or don't have to live, that's where they're going to stay the rest of their lives. So, obviously, if somebody knew that, they would be able to think about whether they really want to plead guilty or not, because when it comes down to it, it's the immigration side of it that's really going to count as far as when you're going to be able to stay here legally in the country. Well, anyways, that was nice for a couple of years, but then the U.S. Supreme Court came out with Chaidez, and that particular case, while it had various arguments and so forth, the bottom line is it said that Padilla is not retroactive, which means if you have a crime that you pled guilty to prior to 2010, and it was final prior to 2010, meaning all your appeals have been exhausted and so forth, um, then you can't cite or use Padilla. Okay. However, and that came out in 2012. However, so basically now the question is there any hope that in fact you can still do both post conviction relief for a pre 2010 final conviction? And the answer is yes. First of all, the China's decision applies the retroactivity principle to federal convictions, not state convictions when you're in state court. So there has essentially been a ruling that the states themselves can determine how Padilla applies or doesn't apply in regards to retroactivity. And just in case you're not 100% clear exactly how retroactivity works, the case is a very good case, Padilla. It says you must give immigration consequences, or you should be able to set aside the guilty plea and the plea deal because there wasn't a knowing plea. The Sixth Amendment violation rights were violated of the particular defendant. Retroactivity means, and we the immigration lawyers want it to be retroactive. In this case, we want to say, okay, you committed, crime was final in 2000 and 1992, whenever, before 2010, and we want to see and argue that Padilla should be applied. The conviction should be vacated because there wasn't the proper advisals given by an immigration attorney. And Chaidez has said, no, 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 you can't go back prior to 2010 and do that because it is a new rule put out by Padilla. It's not an old rule with new facts, new interpretation. It's a new rule, and therefore no retroactivity. But like I was saying, they leave it to the states in which to make rules whether or not Padilla is retroactive or not on state convictions and state court proceedings. So there's already been movement on that, primarily New York, Massachusetts, states like that have essentially ruled that they are able to retroactively use Padilla in order to determine that there was not sufficient rights given and that the Sixth Amendment's rights were violated. There's a lot of states that are on the line right now. There's a lot of states that have it in litigation, so it's really all over the place. But even if you can't argue retroactivity, it doesn't foreclose a lot of other arguments. For example, misrepresentation. If the plea itself was a misrepresentation of what happened, it doesn't matter whether it was a misrepresentation of immigration law or any other kind of law. It should be able to be set aside if there was that misrepresentation. You have to look at the state constitutional provisions that determine whether or not there are specific provisions in regards to immigration. It'll vary state by state. There are different procedures, different arguments that can be used in which to basically get around the retroactivity principle or the lack of it, depending on what state you live in. So don't give up hope. Certainly don't take China's on its face that every case everywhere in the United States prior to 2010 can't be vacated, because it can. There are different arguments. There's different ways that it can be used. And so if you like this video, give me a thumbs up. Go ahead and call me for a free consultation, and then we'll go from there. More on the coming videos.